Yes.
Lordship.
Hmm.
I'm praying for listing of two anticipated bail application as unlisted motion, Lordship.
Okay.
Oblige.
My lord, I have some personal difficulties today. Back to mention item number 6. Can this be taken up to any other date, my lord?
Item number 6.
Yes, it is with 5. 4 or 5, sorry.
5.
Yes.
6 is different.
Yes.
4 and 5.
4 and 5.
Okay, no problem. On the prayer of Mr. Item number 5, Medicare. On the prayer of Mr. D. Pani, list this matters again on 11th.
Next week.
Next week. On 6th. 6th.
Oblige.
Item 4 and 5, my lord, these are connected, my lord.
4. Item number 4, list along with item number 5.
My lord, I beg to mention item number 19.
Item number
19, my lord.
19.
19, my lord. The same released after 3 weeks, my lord.
You are Mr. Pine.
El Kurdu, my lord.
You are appearing on behalf of
Petitioner, my lord.
Mr. Ghosh or
El Kurdu, my lord. El Kurdu. 19, my lord.
Oh, sorry.
19.
A Kudu. On the prayer, made by Mr. K. Kudu, L. Kudu, done a counsel for the petitioner. This matters again after 2 weeks.
3 weeks, my lord.
3 weeks.
Interim
On a
order
date
may
to be
continue.
fixed by the registrar.
My lord, interim may continue, my lord.
The interim order for survey shall continue.
Deeply orders, my lord.
May I, Your Lordship? Your Lordship, I beg to mention item number 3.
Yes.
Your Lordship, the senior counsel on behalf of K. Tama, Your Lordship. Actually, yesterday he was traveling from Zero, Your Lordship. So he is suffering from fever and cold, Your Lordship.
Okay.
So maybe matter may be fixed for tomorrow, Your Lordship.
Tomorrow.
Yes, Your Lordship.
We may have a list. We'll have it. It is that matter. The POSCO section was subsequently on the prayer made on behalf of Mr.
K. Tama.
K. Tama, counsel appearing for the petition. List this matter again on 4/3. Very good.
Your Lordship, on 15th maybe, Your Lordship, because 1st of March, Your Lordship, K. Tama won't be available in station, Your Lordship.
15/3. Yes.
Interim may be continued.
The interim order person.
Oblige, Your Lordship.
May I also, I like to mention item number 13. On behalf of Peter Pups, service is completed. Matter may be fixed for hearing.
We'll see today itself what is there. We'll see today. You're right.
Senior house is
Huh?
Senior is out of it.
Okay. Who is your senior?
Peter Pups.
T. Tapa. On the prayer made on behalf of. Okay. The service is complete. We'll fix it for admissions. Be here. We'll not pass any orders. Don't worry. We'll not pass. Let the matter be called. We'll fix it for admissions. Let the matter be called. Okay.
And my lawsuit, I like to mention other items. Item number 17. 17. On behalf of TP Tara. Due to the personal difficulties.
On the prayer made on behalf of Mr. T.T. Tara, learned counsel for the appellant, list these matters after 2 weeks on date to be fixed by the registrar.
Your Lordship, in this bail application, I was arrested on 29/12/2023. So my prayer today will be that CD may be called, Your Honor.
Yes, madam.
Yes, Your Lordship. CD may be called for.
Your Lordship, the matter may kindly be fixed on 8th March.
Anything auspicious on that day?
No,
Hmm.
nothing of this such, Your Lordship.
8th of March is a holy day.
He wants the day of the court to himself.
7th of March. 7th of March, Your Lordship.
How long can you get your CD by the time?
Yes, Your Lordship.
We'll have it on 6th or 7th, no problem. Heard Mr.
Ketacha.
Thanks, learned counsel for the petition. Also heard members T. Jimmy, learned additional public prosecutor for the state. Issue notice. Call for the case diary of 0 PS case number 42 of the 23 under section 21 bracketed small b of NDPS Act 1985. List again on 7th 2020.
Bless you.
May I please, Your Lordship? It's a regular bill application, my lord. The earlier bill applications are rejected.
This is that where
And
there are
DPS.
two vehicles involved. That Naka, breaking of the Naka.
Yeah, my lord.
Where is Miss Hage? L. Hage? There was a similar matter. She's not here today. Forgot that number. There is another matter connecting to this.
Yes,
thing.
yes, but co-accused is there. I am the.
No, I think I granted him bail also, limited bail that last day. When is this? Do you know that matter?
I could not recall the order, my lord. But he was on suspicion, my lord. He was arrested for much. Nothing has been recovered from his position, my lord. He was arrested from his own residence.
Because
for
the
much.
last date I found that the whole investigation was standstill because they wanted that petitioner therein.
My lord.
So I,
110 kg,
huh?
110 kg of cannabis, commercial quantity.
I know that. And this is cannabis.
Cannabis,
Uh,
yes, my lord.
No, there was a matter, same matter, wherein the investigation was standstill. It was not proceeding. Because the petitioner in that case accused in the other case, other AB, it is an AB. He was not being able to be interrogated. So I granted him interim bail. I fixed the matter when same order in connection with Rupa PS case number,
Yes,
same.
yes,
Only party.
yes, my lord.
Rupa PS case number 15/23 under section 20 bracketed C/25 of NDPS Act 1985. Huh? Date 2. तारीख क्या रखी थी? 7th. Call for the CD रखी बोले. Yes, madam.
Yes.
What is the status?
Uh,
He appeared.
He appeared, Your Lordship.
Okay. What is the stage of the investigation in the matter? You have the CD.
I don't have the CD, Your Lordship.
Do one thing. You get the CD. We'll allow him to appear on the same manner on 29th also.
Yes, Your Lordship.
We'll fix the matter. Thereafter, if we find, we will give him interim bill for the whole period.
Yes, Your Lordship.
Okay.
Charge, in that case, Your Lordship, since the matter has already been charge sheeted, Your Lordship, scan copy of the
We'll ask for this. We'll ask for this.
LCR.
My lord, today, sir, if interim is granted.
No, interim, we are permitting you. Let's see. We'll have the scan copy, then we'll see. If your thing is, we can permit it 302.
Yes, sir.
When is your next examination? It's on 29th, I suppose.
What time?
At page number 15, Your Lordship.
MS T. Ginny, learned additional public prosecutor, has placed on record the instructions received by her from the jail superintendent 0, wherein it has been recorded that the accused, in terms of the orders passed by this court on 21/2/2024 in the present proceedings, was facilitated to appear in the senior secondary examination 2024 held at Government Higher Secondary School, Raga. And thereafter, on conclusion of the exams, he was escorted back to the jail. He was escorted back to the jail premises. Full stop. The next exam of the petitioner, of the accused, is now slated on 29/2/2022. Accordingly, the jail superintendent shall escort the accused to the Government Higher Secondary School, Raga, Arunachal Pradesh, for appearing in his geography paper of Senior Secondary Examinations 2024, starting at 10:30 AM on 29/2/2024, and ensure that the accused reaches the examination center before 10 AM. The authority is also to ensure that the accused, after completion of the examination, is escorted back to the judicial custody. The said authority shall also take proper steps to ensure that the accused, by taking advantage of the liberty granted to him to appear in the said examination, does not flee from the examination center. On completion of the examination and return of the accused to the so-and-so, the jail superintendent shall submit a report to this court through Ms. T. Jenny, additional public prosecutor in this connection. Full stop. Subparallel. Registry to requisition a scanned copy of the lower court records in GR case number
Mm. 71 of 2023.
71 of 2023 pending before the court of
CGM 0.
CGM 0.
It's sessions, but then CGM is taking the judgment.
It has been committed.
No, not yet committed.
Sessions court, so and so, right? List this matter when? Before 18th,
Before 18th,
At least
yeah.
1 week before that, so that we can release it.
Immediately on 4th of
4th, on 4/3/2020. Okay, last line to look at you.
also I may
21/2/2020.
Lordship I may be provided with the order copy, Lordship.
Copy of the order be furnished to Ms. T. Ginny for the needful, for taking further actions in the matter, for taking further steps in the matter. A2L apply A is the bottom paragraph medication. Tarako, last of A2L. Tar Pishat, all for the CD Pishat, LCR Pishat. A2A apply. As you come in, here will be Pishat.
Deeply. Yeah, please.
Yes, madam.
This anticipatory bail has been preferred by the
Have you got it?
applicant.
No, Your Lordship.
Huh?
We have not received the CD. This is the third time that we have given a reminder, Your Lordship.
Why it's not coming?
There is no update on.
We'll ask the IO to come then.
Yes, Your Lordship.
Ms. T. Ginny, learned additional public prosecutor, has submitted that despite repeated reminders being issued from her office to the IO to the IO for production of the case diary in connection with Nahalugun PS case number. It's here only
Yes.
3 of 2022. The case diary is yet to be furnished by the IO concerned. So, in view of the above provision, list this matter again on
First, Your Lordship, because since the IO will be appearing himself, Your Lordship. First,
Give him some time, 2,
Oh.
3 days. We'll give you some time.
yes, Your Lordship.
6/6/3/2024. The investigating officer in Nahalugun PS case number 3/22, the section 120B, 121A, /147, /149, /150, /188, /341, /427, /511 IPC, read with section 83 bracketed 2 of the Juvenile Justice Act 2015, shall remain personally present before this court along with the updated case diary of the said case. The IO is to appear before this court at 10:30 AM on the next date of listing. List again on 6, 6.
Your Lordship may also, I may be given the order copy.
Ms. T. Ginny to communicate the order to the concerned officer in charge of Nahalugun PS Police Station for compliance. A copy of the order be furnished to Ms. So-and-so within the course of the day.
Your Honor, in the meanwhile,
Deeply-
interim may be continued.
The interim order must be issued.
Deeply.
Yes, madam.
Your Lordship, item number 8, 9, and 10 may be passed over for timing.
Let's see whether, madam, you have got your case diary.
Not yet. Your Lordship. Oh, yeah, I have received the case diary.
You have got it.
Yes, Your Lordship.
This is 4.
That is for
4 is by the engineer.
engineering.
So his cases, when he was coming out of the room,
Yes, sir.
the petitioner, one of the lady
Yes, Your
petitioner,
Lordship.
she had pulled his shirt, banged him,
And use line,
but here the witness statement, nothing.
Yes, Your Lordship, the other CD is also of the other case, Your Lordship.
Hmm.
The statement of the accused are all very different, Your Lordship.
No,
It's,
and it was normal.
yes,
Only thing is, we did not see any assault.
yes,
So, allowed,
yes, Your Lordship.
regular bill. What is your name?
A Rai.
Hmm?
A Rai.
K. Rai.
A Rai.
A. Rai. In all the three cases, madam,
Yes.
heard Ms. A. Rai, the counsel, appearing for the petitioners. Dutta, tinta cases, isn't it? Arun, Miss T. Jim, Lanet, additional public prosecutor. We'll pass the orders. Need to dispose of it.
My lord, yeah, in terms of the order dated 22nd too,
You have appeared.
I appeared, I was asked to come again today. I'm right now also I'm there before the PhD. at
So, madam,
PhD.
Yeah, we have not
Wait,
received the,
have we
yes, therefore.
We'll see. Ms. T. Ginny Lanet, additional public prosecutor. Heard Mr. D. Sophie Lanet, counsel for the applicant. Also heard Ms. T. Ginny Lanet, additional public prosecutor, appearing on behalf of Mr. J. Siri Lanet, special counsel for SIT. Ms. Ginny prays for further 10 days time to produce the case diary in connection with Crime Branch case number CB-PS, case number 02/2023 under section 120B/403/406/182 of the 182 IPC. List this matter again on 6/6/6/63 or 7/3/2020. Interim order passed again to continue.
Congratulations.
It's always a pleasure to see you. Yes, sir.
Lordship, this is a review petition. I understand, Lordship, review scope is very limited, Lordship. But then, Lordship, kindly see, Lordship.
No, the points that you have urged
Lordship.
goes on to the merit of the case.
Lordship, here, Lordship, the glaring omission, Lordship. I'm just placed with 3 citations, Lordship. Here,
What do you say,
Lordship,
Mr.
here, my comment on hearing this case, as per order 47. In case, if there is a misplaced of the document or any important things, if it was not placed at the time of argument, in that case, review lies. But not a single grounds of the review has been mentioned in their petition. There is no case at all. So that case is to be, this court should invoke Order 47 Rule 4.
Right, let me hear.
Lordship, this is a lane dispute between the Lordship own
Mr. Padi, you can have your seat.
own Lordship aunt and the Lordship nephew.
Now tell me, what is the glaring error?
Here I'm coming, Lordship. Lordship, Lanet trial court, Lordship, frame 6 issues, Lordship. Issue number 1, Lordship, the maintainability that's inclusive of the Lordship limitation, Lordship. All the 6 issues have been, Lordship, decided in favor of the defendant, that is me, Lordship. And the decree in favor of me, Lordship. Then FOA was filed, Lordship, was appealed against the order, Lordship, by the present respondent, Lordship. Now, kindly come to the order on which the impugned order has been passed and which is sought to be reviewed in the present review petition, Lordship. Lordship,
Para 9.
kindly come to page 16. It starts from page 16, Lordship.
Para?
It starts from page 16, Lordship.
Para.
Para, Lordship. Para 9, 11, 15 onwards, Lordship.
15 on.
15 onwards.
Hmm.
Mr. So and so, learned senior counsel appearing on behalf of the plaintiff appellant has submitted the identity of the suit along with its four boundaries described in the schedule of plaint is not disputed, and that except in town areas, no revenue record is maintained in respect of land of Arunachal Pradesh, and no revenue is also collected. On the other hand, Mr. So and so, learned counsel for the dependent respondent has submitted that the Keva decisions of so and so were forged document and made at later stage, and locations of the suit land by its name and boundary as contained in plaintiff are vague. Therefore, the point in issue between the parties in regard to identity of the suit land by its name and its boundary being surrounded by confusion, this court is of the view that the aforesaid confusions could have been removed for the purpose of proper appreciations of the evidence of both the parties side, and had the suit land been locally investigated, issuing an appropriate commissions for local investigation as provided under order 26 rule 9 of the CPC to find out the exact locations of suit land along with its four boundaries, which has not been done in the instance suit. Further, so and so alleged the plaintiff filed a translated copy of Keva decisions of 92 and 96. It has been further alleged that the aforesaid translations are misleading, interpolated, and version contained therein are inconsistent with the contents of the gist of the original document, and that the Keva decisions seems to be completely fabricated, wherein the date, contents, and name of the suit land are completely changed from that of the original document. It is also contended that the thumb impression of the signature of Jumbo Author in the document annexure so and so are false, and such the said documents are fabricated. Therefore, in the opinion of this court, it would be convenient if the disputed question documents are subjected to scientific investigation as provided under the Order 26 Rule 10A of the CPC in aid of appreciations of the oral testimony of the witnesses of both the parties. For a reason set forth above, the appeal is partly allowed, setting aside the impugned judgment and decree dated so and so, passed by so and so. The suit is remanded back to the learned trial court with direction to issue appropriate commission under Order 26 Rule 9 for local investigation in respect of the suit land to elucidate its exact location and boundary thereof, and further another commissions under Order 26 Rule 10A of the CPC for scientific investigation into question documents, disputed documents, including signature or thumb impression, etc., thereon by the forensic science laboratory. After hearing the learned counsel both the party, both the sides on the procedure to be followed and terms of reference for investigation and thereafter to dispose of suit appraised in accordance with the law, lawship.
Now,
The 6 issues lawship. On which lawship appeal was filed lawship?
I got it. You come to para 13.
13 lawship. Lawship.
So the situs of the land was, a dispute was sought to be raised.
Lawship.
So your case is whether it is Mibu or Bibu,
Lawship.
the land location would be the same.
Same lawship.
It will not change.
It's not change.
Then come to para 13.
It is noticed that the learned trial court has admitted photocopy of documents, some of which are not readable and not even compared with the original and signed by the presiding officer of the court to identify the same. It is not even discernible from evidence as to whether the exhibited documents were admitted with objections or without objections of the adverse party. The documents admitted with objections or without the documents upon which reliance is sought to be placed must be brought on recourse of the case legally because the documents do not prove themselves. Further, secondary evidence should not be accepted without a sufficient reason being given for non-productions of original, and if the truth of the facts stated in a document is in issue, the same need not to be proved by oral testimony. The oral testimony in deserving cases may well be appreciated with the aid of the opinion of handwriting expert on the disputed documents. Here, Lordship, what I'm,
Para 14.
Lordship. Thus, the evidence of both the sides reveal that there is inconsistency and contradiction in name of the suit land, which is significant in regards of its location with reference to the name of the stream on the bank of which it is exactly situated. Perusal of the schedule of the suit land given in the plan reveals that on the note of it there is a Bibu river land of Bake Kamduk, but in evidence the plaintiff oblique appellant without mentioning the name of river stated that on the note there is a lane of Sri Bake Kamduk. Then Lordship 15 I have read.
So
Here Lordship,
so 13 and 14 literally led to 15 onwards. Conclusion.
Here Lordship, so far this lane is concerned, the location of lane is concerned, Lordship. It's not disputed, Lordship. In plain, as well as in the written statement, Lordship. Filed by party, Lordship. In paragraph 15, Lordship, the petitioner, the appellant himself has stated, Lordship, it's not disputed, Lordship. Paragraph 15, Lordship. Paragraph 15, Lordship. I have read, Lordship. Mr. So and so. It's not disputed by us also, Lordship. Now, what I'm pointing out is, Lordship, the issues on which the appeal was filed, Lordship, which is inclusive of the maintainability of the Lordship suit. At least all those issues should have been addressed by the learned, this honorable court, Lordship, in the appellate forum, Lordship, and which has not been done, Lordship. 1, 2, 3, 4, 5, 6 issues. 6 issues are the basis on which the appeal was filed by the present respondent, Lordship. Not the even issues, one single issue was addressed by this honorable court, Lordship. Therefore, this is a glaring omission, Lordship.
Okay. So this is your...
One is the, Lordship, the limitation. Limitation has been decided in favor of me, Lordship, by the learned trial court. And that was also placed before this honorable court in the appeal, Lordship. And that also has not been addressed, Lordship. That has not even considered, Lordship. None of the Lordship issues, Lordship. And so for location and this Lordship.
So this is basically an application for review of merits. Review on merits.
No, Lordship. Because there's an omission. Omission is that, Lordship, the appellate court, Lordship, the duty of the appellate court, Lordship. It has been already described, provided in the Lordship CPC, what the appellate court ought to do, Lordship.
No, if this is an omission,
Lordship,
it's an omission which can be corrected by a higher court.
Lordship, therefore, Lordship, I'll place 2, 3 citation, Lordship. Then Lordship may consider, Lordship. Why? Because omission, Lordship, led to, Lordship, passing of wrong judgment, Lordship. And omission has not been done, Lordship, by giving the reason, Lordship. Had it been done by giving reason, the omission, Lordship, then, Lordship, it becomes the subject matter of appeal, Lordship. If omission is by reason, then, Lordship, I can understand, Lordship. Then I can come for review, Lordship. Those omissions are, Lordship, omission without any reason, Lordship.
No, omission means omission. Even reasons will not take it out. But here, what the court had done is, this court had done is, it noticed an issue. And they said that in paragraph 13, documents were not proved in original. And both this together said that exact location of the land, there is some confusion, which the judgment does not address. Judgment in appeal does not address. And accordingly, it proceeded with this. Fine, no problem. Now you show me the decision of the Supreme Court.
Yes.
Even in such circumstances, a review would be maintained.
Lordship, I'll just place and
it would be on merits. It's an appellate court. Appellate court found. Show me, let's see. Let me
Lordship,
also-
Lordship may examine, Lordship.
Please don't mind me asking questions, it's just for clarification.
No, no, it's okay. Lordship, before coming to Lordship, that particular judgment, Lordship, I would like to take Lordship to the page 17, Lordship.
This petition.
No, this, I have already, paginations I have done. for
Okay,
you,
okay,
Lordship.
thank you.
Paragraph 17, Lordship. This is 2024 SCC 313, Lordship.
17.
Page 17, Lordship.
17 is not here, 16. I have till 16.
Then kind of 18.
No, only page 16 it is. Which is the paragraph of the judgment?
This is paragraph 13, Lordship.
18, no, para 18. You want to refer to para 18?
Para 13, Lordship.
Para?
Para 13.
13.
One
Okay,
three,
fine,
Lordship.
okay, fine, okay, yes.
It's at page 21. Lordship.
Yeah.
It is a settled positions of law that an appeal is a continuation of the proceedings of the original court. Ordinarily, the appellate court jurisdictions involves a rehearing on law as well as on fact, and is invoked by an aggrieved person. The first appeal is a valuable right of the appellant, and then all questions of facts and law decided by the trial court are open for reconsiderations. Therefore, the first appellate court is required to address itself to all the issues and decide the case by giving reason. The court of first appeal must record its findings only after dealing with all issues of law as well as fact and with evidence, oral as well as documentary led by the parties. The judgment of the first appellate court must display conscious applications of mind and record findings supported by reasons on all issues and contentions, so and so, Lordship. So this is the Lordship. One thing, then kindly come to the first Lordship, the first page, the front page. Next page, Lordship, page 2. This is a very short judgment, Lordship. Mr. So and so learned counsel for petitioner has argued at length all the points which were urged at earlier stage when we refused special leave, thus making out that a review proceeding virtually amounts to rehearing. Maybe we are not right in refusing a special leave in first round, but once an order has been passed by this court, a review thereof must be subject to the rules of the game and cannot be lightly entertained. A review of a judgment is a serious step, and reluctant resort to it is proper only where glaring omission or patent mistake or like grave error has crept into earlier by judicial fallibility, Lordship. There is a judicial fallibility and glaring omission. A mere repetition through different counsel of all and overruled arguments, a second trip over ineffectually covered ground, or minor mistake of inconsequential import are obviously insufficient. Inconsequential, here the consequential, Lordship. The very strict need for compliance with this factor is the rationale behind the insistence of counsel's certificate, which should not be a routine affair or habitual step. It is neither fairness to the court, which decided, nor awareness of the precious public time lost what with a huge backlog of dockets waiting in the queue for disposal. For counsel to issue easy certificate for entertainment of review and fight over again the same battle which has been fought and lost. The bench and the bar, we are sure, are jointly concerned in the conservation of the judicial time for maximum use. We regret to say that this case is typical of unfortunate but frequent phenomenon of repeated performance with review level as passport. Nothing which we did not hear then has been heard now, except a couple of rulings on points earlier put forward. Maybe as a council now urges and then pass. Our order refusing special leave was capable of different course. The present stage is not a virgin ground, but review of an earlier order which has been normal, which has the normal feature of finality. Dismiss the so and so lawsuit. Here, lawsuit, the glaring omission lawsuit. I'm emphasizing on this laws. Here, all the issues have been brought before this honorable court by way of appeal by the present respondent, but all of them have not been considered. And then next lawsuit. Next is lawsuit paragraph 1980 supply SEC 562 paragraph 12 laws. This same thing has been repeated, lawsuit here, cited lawsuit. A review is not a routine procedure.
It
Here-
follows the earlier one.
Lawsuit. Here, lawsuit, early order, unless many persons so and so undermines the soundness or result in miscarriage of justice lawsuit. Here in our case, law, had it been decided, had all the issues have been decided lawsuit, including the lawsuit, limitation lawsuit, the matter would have been something different lawsuit. Then kindly come to page lawsuit 15 lawsuit. This is 2013 at SCC 337 lawsuit. It starts from page 9, and I'm taking lawsuit to paragraph para 25 lawsuit. Para 25 lawsuit. In the present case, the error contemplated in the impugned judgment is not one which is apparent on the face of the records. Rather, the dispute is wholly founded on the point of interpretations and applicability of sections 11.2 and 11.4 of MMDR Act. In review jurisdiction, mere disagreement with the view of the judgment cannot be the ground for invoking the same, as long as the point is already dealt with and answered lawsuit. The parties are not entitled to challenge the impugned judgment in the guise of that an alternative view is possible under review jurisdiction. Hence, in review jurisdiction, the court shall intervene only when there is a glaring omission or patent mistake, or when a grave error has crept in the impugned judgment, which we fail to notice in the present case lawsuit, in that case lawsuit. So these lawsuit, what I'm trying to point out lawsuit is just I'm repeating the thing lawsuit. The Honorable Supreme Court talks about the lawsuit glaring omission and miscarriage of justice lawsuit, which has happened in this present case lawsuit. As I have submitted lawsuit, had all the issues have been decided lawsuit, definitely lawsuit, the answer would have been something different than the present order lawsuit.
Now, your contention is that this court ought to have decided all the 6 issues. first,
All the 6 issues.
and thereafter proceeded with the matter.
Correct.
But this court limited itself to issue number 2, because it may have felt that a decision in issue number 2 will result in the other issues being decided. Because first decision in issue number 2 was to be decided. So issue number 2 is whether the land in question is called Bibu, Bibu or Pogdu, right? And thereafter the discussion from paragraph 10 onwards started. And therein the court noticed that there is, in the evidence stage, there is a doubt as to whether, because a disputed question has been risen, and that disputed question was supposedly to be answered by the trial court. basing on documents, secondary evidence basically, without even asking for whether that has been compared with the original or it has been exhibited with or without objection of the opposite party. Then it went ahead and said this issue we hold that has not been finally decided. So you have to decide. Basically, issue number 2. And thereafter to dispose the suit afresh in accordance with law. But while interfering, it interfered with the whole.
That's the thing, Lordship. Because the things which has been decided, even if it has to be reheard, that has to be nullified.
On that specific point.
Lordship. Otherwise, which has been decided correctly, that cannot be remanded back for Lordship, reheard on merit again, Lordship. Unless that's vitiated by Lordship, any kind of Lordship, legal infirmity, Lordship. And apart from that, Lordship, the documents which is said to have been Lordship, produced, Lordship, without there being an original Lordship, documents, Lordship, that has not been even exhibited, Lordship. And that document is the Keba decision between the present respondent and his own younger brother, Lordship. And that has nothing to do with the Lordship, actually, the present land, Lordship. Apart from that, Lordship, so for Bibu lane or Mebu lane, Lordship, it's discernible from the pleadings of the parties, Lordship, plain and the Lordship written statement. Description, Lordship, the exact location. Location is not disputed, Lordship. The issue number 2 is, Lordship, whether it's called Mebu, Bibu, Pagdum or Bibu lane. There's the issue number 2, Lordship. Issue number 2 is not about the Lordship, locations of the lane, Lordship. The issue number 2. It's not about the locations of the lane, if Lordship see the issue number 2. Location is not disputed, Lordship.
Will say that. Yes, Mr. Patel.
My submission here in the case is that the petitioner has taken the ground for review. First ground, for the reason that the judgment and order dated on 21/11/2017 is not based on the material evidence available on record. Second, for the reasons that while passing the judgment and order dated on 21/11/2017, this honorable court opted for 2 new issues which has no real dispute on record, and this honorable court was led to pass such an erroneous order due to one of proper perusal of material evidence on record. For the reason that the respondent approached this honorable court by appeal assigning the judgment and decree dated on 21/2014, passed in title suit number such and such on all 6 issues, but while deciding the appeal, this honorable court left out all the 6 issues without decision thereon. Had all the 6 issues have been decided, the appeal of the present respondent would have been dismissed in one of merit. Now, for the reason that inter alia the learned trial court rejected the case of the plaintiff on the ground of limitation, but while deciding the appeal, this honorable court failed to decide the same, whereas the same is a vital issue which required consideration on priority. For that, the reasons that the copy of Keba decision dated on 1992 was duly compared with the true copy without any objection. Further, the copy of the Keba decision of 1992 was not exhibited by the plaintiff. For that, the reasons that the case of the appellant in appeal is devoid of merit, and if the same is allowed, then the same shall be causing irreparable losses to the petitioner. This is the ground taken by the petitioner. Now, the citation which is related. That is only on the basis of the appeal ground. But here in my case is that it is not an appeal. It is a review. When it is a review, in that case, what are the review grounds? Review ground is Order 47, Rule 1, so that review of a judgment or an order could be brought
Mr.
from.
Patil, the trial court judgment is not on the.
Yes, no dialogue. I think
Because one point he has taken up is that the point of limitation was decided against you in the trial court. Issue number 1 was decided against.
Yes.
So if that was decided against you, then although it's not his point here, but if that was decided against you, without a contrary decision on that, could this order be have been passed? We would like to see that trial court judgment. I think the records of the.
FAO. That appellate order, sorry, FAO number 3 of 2014 lawsuit.
FAO number?
3 of 2014.
Records of FAO.
Anything. Huh?
FAO can be, FAO का records. Too technical.
Limitation was not the ground.
Normally tagged, no?
I'm sorry, lawsuit. Sorry.
Because without that, we cannot appreciate this. So, Patil, we'll ask that records to be tagged here. Huh? Then we will see. Because if we'll have to look into that issue number 1, how it was decided. Have you taken a ground with regard to issue number 1?
Lawsuit, if lawsuit say my ground number 2 lawsuit.
Because Mr. Patil is correct. With regard to issue number 2, these grounds are not sufficient for review. But let's see with regard to 1.
Ground number 3 lawsuit. I said lawsuit, all the 6 issues. 6 issues inclusive of that issue number 1 lawsuit.
Okay, 3 may be somewhere near.
Lawsuit.
But again, whether that would be a ground for review.
Lawsuit, judicial fallibility.
No.
And then lawsuit.
Review is very narrow, as Mr. Patil has. It's very narrow.
That I understand lawsuit. As I placed the Honorable Supreme Court.
That is a different, that's a general sort of thing. But you will have to bring your case within Order 47.
That is. Lawsuit, what I understand, lawsuit, what had happened in the present case, lawsuit.
What do Mr. Patil, when it become comfortable for you to have it fixed?
मार्च में करो मार्च दे दो ले लो
But issue number 1, if it is decided against the plaintiff, we'll have to look into it. Because that has been set aside now by consequence. So there is no discussion on this. That's it.
11 March. 11 March.
11th would be compatible.
No issue.
Her the parties. सबका नाम ले लीजिएगा, पाटिल सबका भी नाम लिखिए. They wish to tag the records of FAO number 3 of
to the importing lawsuit.
the trial court judgment is there.
Yes, trial court judgment. Everything is
3/AP
yes,
2014, along with the records of this case. List again on 11/3/2020. Mr. Patil, on that day, you will be fine. You can keep this. You can give it to me on that. But just see your paginations. I think there's some error there. Yes.
My lord, service is completed.
Same day, office note dated 25/1/2024. The service on respondent number 2 is duly effected. Accordingly, service in the matter is completed. List the matter for admission when
4th March.
on 4/3/2024.
We please, Your Lord.
Yes.
Earlier occasion, I was directed to take dusty service upon the respondent. So the respondent is living at Tooting. So service has not yet been completed.
No. Only sole respondent.
Sole respondent, only sole.
Completed. 23/2/2024, AD card returned back to this registry after duly service of notice in respect of sole respondent. So
Okay.
it has been.
It has not enlightened. I was not enlightened about. Now,
Proprietor KO Osik.
yes, OC.
None has appeared, no?
None has appeared till then. My lord, they are filing one execution petition in the trial court below. So now stay is required.
No, we'll give them one more because it was just effective the other day.
Yes,
We'll give them one more date.
yes, sir.
They consider the note dated or the consider the office note dated 23/2/2024, wherein it has been recorded that the service of notice upon the sole respondent is complete. Full stop. So amendment you have given up now.
Yes, yes. Amendment.
List this matter again for admission. Admission, madam?
Yes.
For admission. Yeah, that's what admission. Comes up for admission.
Yes, my lord. Admission hearing, my lord.
For admission hearing on 11/3/2024. We'll consider that.
Yes, highly obliged.
Lordship, this is in connection to arrest and negligence allegations made by these prosecutions. So matter is before the Honorable Chief Judicial Magistrate Court. So Lordship, we have filed this petition under section 482 of CRPC. So issue is only that Lordship, FIR in the page number Lordship 17. To understand this court, may I read out the FIR Lordship? Page 20.
Your case is that it was carrying goods within the permitted limit.
Yes, Lordship.
And you rely on the GST invoice and the income tax.
Yes,
Yeah.
that as part is.
The case of the prosecution is that it was overloaded.
Yes, exactly. Yes.
So if it is overloaded, then you are at fault. The prosecution lies against you.
Yes.
Cannot be interfered with in such like matter. Yes,
But-
what do you say?
Your Lordship, I will come to that, but prior to that, Your Lordship, there are some procedure which has to be complied with regarding Your Lordship implement of the victim.
It has not been done.
Yes, Your Lordship. Your Lordship may kindly come to this page number in their petition. Page number, Your Lordship, 50, Your Lordship. Down below, Your Lordship, left side, Your Lordship will find the particular of deceased. Hirak Kalita, 18 years, male, son of Sri Joten Kalita, village Gograpar, POPS Gograpar, district Nalbari, Assam. So address is there, Your Lordship. So as per the, Your Lordship, Guwahati High Court rule, chapter 11, criminal business, 1A, which mandate the implement of the victim. Victim include, Your Lordship is aware, victim family member. So, Your Lordship, they ought to have implemented the victim.
Yes, he's right.
Yes, Lordship, but thing is that Lordship, we are on the case of this Learned Chief Judicial Magistrate order dated
Whatever.
24/7, that is
Whatever.
consideration of charge, Lordship.
Whatever it is.
So Lordship,
You implead him.
so Lordship, in this case, actually, this party are not interested, Lordship, because that body also taken by us to the native place owner after this legal
That
formality.
is a different thing altogether. Whether they come, they don't come, it's a different aspect also. The step that you have to take, you take, file an implementing application.
Additional affidavit will come.
Okay. And on merits, what do you have to say?
Merits, your lordship has rightly pointed out on the supplementary charge sheet. It has written if it is overloaded, then the section come. If there is no any remark as such, then it will purely an accident. But that remark is that overloading.
Overloading.
So for that, your lordship trial.
Trial would be.
Yes, your lordship.
So Lordship, overloading in go to the this police charge, Lordship.
No, not on that. Now that there is a dispute, you say GST. Income tax
Yes,
says 20 tons. But the MBI report in the supplementary charge sheet says more than that, overloading. Now, this is an issue which has to be decided in trial.
But Lordship, in this case, who are going to prove the case, Lordship? Question number one. The complainant, the petitioner has been made as the accused person in this case. So go through this FIR, Lordship.
I know, I've seen that.
Lordship, FIR in this case, Lordship. Thing is that, Lordship, this Panidhar Kalita is the owner of the vehicle. He was not lodged the FIR, but prosecution has made this person as a complainant in page number 24 of the charge sheet, Lordship. The FIR is first route is the Lordship FIR in criminal case.
That was done by you.
FIR was made by myself for legal formalities. But police's Lordship, again my FIR has been registered. Despite of that, Lordship, police has made Panidhar Kalita, who is the owner of the vehicle himself, that person has been made as the complainant in this case, Lordship. So one more is Om Prakash Sharma. This person also not so relevant, Lordship.
Okay,
So-
you make your that
So
that thing come. We'll think about this.
Lordship, this charge is also totally defective, Lordship. Defective charge sheet, Lordship. Because
We'll consider once the whole thing is ready.
Lordship, this FIR also totally
But
defective.
the supplementary charge sheet,
Supplement charge is nothing, Lordship. Supplement charge it only says about that page number 68, Lordship.
66.
Yes,
66.
and last page. Lordship, supplementary charge sheet, nothing says that MBI is it from serial number 1, name of address, register owner not known, name of driver not known, driving license.
On
all
the
not-
prayer of the learned counsel for the petition, list this matter after week,
after
file that implementing application.
after 1 week, Lord.
Or after 1 week, enabling him to take steps for implementing the victim or the family, the legal heirs of the victim as party respondent in the present. Prayer allow, list the matter after a week on a date to fix by the registry.
Deeply
A
obliged.
list the matter after a week
After
on
week, Lord.
filing of the interlocutory application by the petitioner.
Deeply obliged.
Yes.
My lord, this is an application for condonation of delay of 92 days in preparing an appeal, my lord, criminal appeal, my lord. So there was communication gap between my lord, the appellant and his previous counsel, my lord. And
Mr. So-and-so, also Mr. So-and-so, party, take it go. Issue notice. Of course, this is an application, this is an application, interlocutory application filed by the applicant oblique appellant, praying for condonation of delay of 90 days in filing the connected criminal appeal against the judgment and order dated 22/9/2023 passed by the learned special judge POSCO East Siang District Pasighat in POSCO case number 9/18 under section 448/354, bracketed A, bracketed 1, terms of small Roman 1/376/511 IPC, read with section E of the post square. Full stop. Issue notice, returnable 4 weeks. Petitioner to take steps. For so-and-so, the additional public prosecutor accepts notice on behalf of the opposite party number 1. Petitioner to take steps for service of notice upon the respondent number 2 by way of registered through the officer in charge of what would be the police station?
Pasigat.
Pasigat.
Yeah.
Police station, right?
Yes, Your Lordship.
My lord,
Such notice will be routed through the registry of the school. Right?
my lord, we may be allowed to cause dusty service also. ma'am.
Otherwise not permissible.
Officer in charge. You take it from here. They will send it to that and then you do. List the matter after 4 weeks with a note pertaining to the status of service of notice upon the respondent.
Deeply obliged.
Sorry, a bit late. Yes.
Wait, please, Lord. So item number 22 may be taken first, Lordship. Item number 22. Connected matters. Deep payment. FIR on page number 10. Section involved is 302, Lordship. Page number 12 is the FIR. One lady was found dead in her rented house, and as per the FIR, the apparent cause of death is strangulation. Here, Lordship, I am not named in the FIR. Also, I am a resident of Lakhimpur district. 3 years ago, Lordship, I have worked in the village of the deceased, and I developed a relationship with the deceased 3 years ago. Subsequently, Lordship, few months after the relationship, it was 2 years ago, I left for Ahmedabad for better work opportunity. For last 2 years, I had no relationship with the deceased. Now I got married, Lordship. I have a 3 months old son, Lordship. Since I had a relationship in the past, that is why perhaps police is calling me to the police station.
And who is the other one?
Other two is the father of the main accused, Deep Parme, and the elder brother. And they had nothing to do with this case. Since they were issued 2 notices under section 160 of the CRPC, asking them to appear before the police. The notices, and the police is saying that you produce Deep Parme before us, otherwise you will be in trouble. That is why we are apprehending heirs, the father and the elder brother.
That means there is some material against you, maybe.
That's perhaps, but so far as let's say, my instruction is that 2 years that Deep Parme, the main accused, as per the police, had no relationship with the deceased.
Yes, madam.
Yes, Your Lordship, CD may be called for. Your Lordship will see the FIR was filed on 16/12/2023, Your Lordship. So the investigation must have progressed, and since they are being called by the police, Your Lordship, there must be some materials against them.
So far as Lordship, deep permit, I am not pressing for the interim parent, Lordship. But in item number 21, the father of the deep permit and the elder brother, Lordship, they got two notices, Lordship, kindly see. Page number 16 and 17. Lordship, and so far as these notices are concerned, Lordship, these notices are also illegal, Lordship, so far as section 160 is concerned. I'm coming to that, Lordship. Lordship. Anyway, so we are ready to appear before the police. But so far as Lordship, father and the elder brother, they even do not know who is the disease. And never visit, even have no connection whatsoever. Lordship.
Okay, when can you get the CD, ma'am?
On 4th, Your Lordship.
So I'm praying for interim Lordship so far as father and the elder brother is concerned.
Okay. We'll run them in bit, ask them to,
Yes, only in item number,
the second one.
Second,
Father,
yes.
This one, again.
yes, yes.
Third, item number 20. 21, April 34. Heard Mr. B. Bora, counsel appearing for the petitioner, also heard Ms. P. Jing, an additional public prosecutor for the state. Issue notice, call for the case diary. List this matter again on 4/3/2024. Will do?
Yes, sir.
And with item number 21. 21, huh? 4/22, huh? 21.
Lordship, so far, can it be date is 5th of March, Lordship, if possible? 5th of March.
problem.
Yes, no
5th of-
5th.
5th of-
इसमें वो हम लोग जो है हर्ट बोरा जिमी entitled to benefit of pay जो ऑर्डर हम लोग का है उसमें खाली वो कंडीशंस जो होगा सही लगा दीजिएगा और 15,000 each petitioners हो जाएगा
Also, Your Lordship, if they are, since the notice, the period of their appearance has already been lapsed, Your Lordship, they may appear before the IO after 2 days, Your Lordship.
No, I'm saying 7 days.
Oh,
In the
7
period of 7 days, they'll appear.
Yes.
I'm deeply.
If, deeply.
That will do.
Yes, Your
7
Lordship.
days.
Since the matter is fixed on 5th, Your Lordship.
No, it will not be possible. We'll,
Yes.
we'll delay it a bit more. When do you, 11th?
11th, 12th, Lordship.
12th.
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 12th, huh?
Lovely.
Deeply.
Yes, Mr. Decker, what are you waiting for?
Last item 20.
Okay.
Mayor, Lordship. Lordship, I'm on behalf of Mr. T. Siring, leading counsel for the sole respondent. Currently, he is out of station, therefore this matter may be adjourned for the day.
When do you want it? You're coming from outside.
Yes, from outside, from Lakhimpur. I have been appearing today is third day. And the
So
case
last
was-
chance.
See,
Yes,
This is the courtesy we have,
Yes.
you have between councils.
yes.
People have problems, maybe.
Yes.
It's not that you don't have problems. But at least have that courtesy to call up the council and tell him
Yes,
that this is my problem, he'll not be doing it.
yes,
Then he comes, it's his. Right?
Yes.
Then you can make a mention to the school that we have informed them.
yes,
That's enough.
yes,
So next time you're a young council, next time kindly follow this.
yes,
Okay?
yes.
This
Lots-
time excuse them, next time onwards.
Okay,
they will do
okay.
it.
Lordship,
Next
one
Last chance, one.
more
You
submission.
take the learned council's number.
Yes, Lord.
Yes.
One more prayer. Lordship, may kindly direct the registry for preparation of paper book.
Oh, that we'll see whenever the matter is. I don't think so. Records are here.
LCR, yes.
LCR with the record.
Do you require a paper book for this? No?
For better convenience to
Next
assist.
with record.
Small point is, on the prayer made on behalf of her, so give it.
Lordship, may
I'll fix it.
15th March. On 15th.
On the prayer made on behalf of Mr. D. Sil, Nanak Council, given for the respondent,
Sole respondent.
sole respondent, list this matter again on. Council 14 would be inconvenient. Convenient? No, not 15. 14. He'll not be here on.
Okay, 14.
Okay, 14.
14.
Yes.
14/3/2024. Stop. On the next date fix. Malay.
I don't mention his last son because they are
No,
appearing without any steps.
The parties, the respondents are. Also, the respondents were given last chance to argue one more chance to argue the matter while order dated 12/2/2024. As the case has been adjourned today on the prayer made by the council for the respondent, on the next day, last chance is given to the respondent to place their, to make submissions in the matter, failing which orders as may be called for. Appropriate orders as may be called for would be passed in the matter.
Hello.
Next time something is there. Always.
Yes, Lord.
Communities. Item number 20. That matter.
Yes, my lord. Maybe the appellant is appearing through PC.
Yeah, madam.
Yes, Lordship can see me. Lordship, I have furnished my written submission.
Where?
I think it's on record. Written submission along with the citations.
Written submission date.
We were informed that it's with the records.
Madam, you have given a mail.
Yes.
Along with a citation.
No, we have also given a separate citation which was submitted by the council. Written submission on 23/2/2024. I was told it's on, it's with the records.
Oh, it's not here.
23/2.
Ma'am, they gave it to the registry or the bench assistant?
To the registry.
You have also submitted.
It has been received also, Lord, on 23rd/2.
Received by whom?
Deputy Registrar Judicial.
I'm sorry, my lord. I could not submit the judgments prior. So I will submit today, my lord.
We can submit it. I just wanted it before because so that I can just go through it.
Yes, I understand, my lord, but I could not find out the judgments.
That means madam has a point.
No.
Yes.
Now
he could not find any judgment. That means I said at least you have given me one.
No, Lordship, I have given three, actually four. Four. One Punjab and Haryana High Court and three Supreme Court.
No problem.
Lordship, has Lordship got the written submission?
They say they have just let me wait. There is a office note also. That they say it must be it's here.
Yes,
they have put it here. They have made it a part of the pleadings.
I see. Lordship, I have given the Lordship, I have given the relevant dates also, which is at the second page of my written submission.
Yes. It's there.
On 27/11/2020, the plaintiff was directed to take steps by registered post with acknowledgement due upon the defendants, and 15/2/2021 was fixed for the service report and WS. And 15/1/2020, the fresh summons were again directed to be issued, fixing 17/2/2021 for filing WS. Then on 17/2/2021, that newspaper order was given for newspaper publication. And newspaper publications, what was the order? The order was to publish the notices in any national newspapers. Contrary to that, the plaintiff published in 3 newspapers on 26/2/2021, the Sentinel, the Dainik Asam, and the Echo of Arunachal Pradesh. But the newspaper in the national daily, it was not published. None of these are national dailies. Lordship, before I come, that's only one of the points. Before I come to that, Lordship will find how the service was done. Thereafter, Lordship, 13/4, it was ordered for ex parte. And on 22/1/2021, ex parte judgment and decree was passed. Then we filed our application under Order 9, Rule 13, being this case 12/2003, and that was rejected, Lordship. And it was held, Lordship will see at page 3, thus the court is justified in page 3 of my written submission. I've quoted it, Lordship. This is the impugned order. Please ask her to shut up. Give him. Has Lordship found the order? Yes. Thus, the court is justified in arriving to go for substituted service against the defendant in the order dated 17/2/2021, though no reason assigned. Further, the plea set up by the applicant that until 22/5/2023, no summons were received by the applicant does not transpire confidence to be relied as the mode of service of summons in the execution case is also through registered post acknowledged AD, and the same address of the applicant in the summons was sent in the money suit through registered post AD. And it is not a case of the applicant that the address is wrong address for which the summons could not have been served. Thus, I'm convinced that with the plea taken by the respondent plaintiff, the applicant could not give possible justification for not appearing and for not participating in the proceedings of the money suit. Now, Lordship will find, I'll just take Lordship to Order 5, Rule 9, which of the CPC, Rule 9, which deals with delivery of summons by court.
Wait, go.
CPC Order Rule 9. One talks when the
Order 5 rule?
Rule 9, delivery of summons by court. One, when the defendant resides within the jurisdiction of the court in which the suit is instituted, or has an agent residing within the jurisdiction who is empowered to accept service of the summons shall, unless the court otherwise directs, be delivered or sent either to the proper officer to be served by him or one of his subordinates or through such courier service as are approved by the court. Then the 2 deals with the proper officer. 3 says the summons may be made by delivery or transmitting copy thereof by registered post acknowledgement due, addressed to the defendant or his agent empowered to accept the service, or by speed post or by such courier service as are approved by the High Court or by the court referred to in such subrule. Then subrule 1, or any other means of transmission of documents, including fax message or electronic mail service, provided by the rules made by the High Court. provided the service of summons under this sub-rule shall be made at the expense of the plaintiff. Now, what is important is sub-rule 4, Lordship. Now, Lordship will see that the case was filed at Alo, and the defendant number 1 is a resident of Guwahati, which is outside the territorial jurisdiction of Alo. And defendant number 2 is in Meghalaya, which is in a different state, or both are different states and outside the territorial jurisdiction of Alo. So rule 4 comes into play, 9(4) comes into play. Notwithstanding anything contained in sub-rule 1, where the defendant resides outside the jurisdiction of the court in which the suit is instituted, the court directs service of summons on the defendant may be made by such mode of service of summons as referred to in sub-rule 3, except by registered post acknowledgement due. The provisions of section 20 or rule 21 shall not apply. Now, this is by ours was by registered post, so rule 21 comes into play. Now, rule 21, Lordship says, a summons may be sent by the court in which it is issued, whether within or without the state, either by one of its officers or by post or by such courier service as may be approved by the High Court by faxing message or by electronic media service or by any other means as provided by the court, by the rules made in the High Court, not being a court having jurisdiction over the place where the defendant resides. So this summons has to be sent to a court which has jurisdiction over the place where the defendant resides. The summons cannot be sent by registered post directly to the defendant, but to a court, not being a high court, which has jurisdiction in the place where the defendants reside. This was not done. And then what happens? 22 comes into play, where summons issued by the court established beyond the limits of the town. 23, Lordship. The court to which the summons is sent under Rule 21 or Rule 22 shall, upon receipt thereon, proceed as if it has been issued by such court, and shall then return the summons to the court of issue, together with the record, if any, of its proceedings with regard thereon. Now, Lordship, in the present case, the defendants having resided outside the territorial jurisdiction, 21 comes, and order was for registered post, 21 comes into play. And there is another mandate, Lordship. What about procedure? Lordship will find in the entire pleadings, in the entire case before the trial, there is not a whisper that the defendant refused to accept the summons. Even the registered AD has not gone back. There is no tracking report. And Rule 17, Lordship. Procedure when the defendant refused to accept notice or cannot be found. When the defendant or his agent or such other person as aforesaid refuses to sign the acknowledgement, or where the service officer, after using all due care and reasonable diligence, cannot find the defendant who is absent from his residence at the time when the service is sought to be effected on him at his residence, and there is not likelihood of his being found in the residence within reasonable time, and there is no agent empowered to accept the service of summons on his behalf, nor any other person on whom the service can be made, the service officer shall affix a copy of the summons on the outer door or some other conspicuous part of the house in which the defendant ordinarily resides or carries on his business or personally works for gain, and shall then return the original to the court from which it is issued, which is with a report endorsed thereon or annexed thereon, stating that he had affixed a copy and the circumstances under which he did so, and the name and address of the person, if any, by whom the house is identified in whose presence the copy was served. Now, in our case, nothing has been done. Registered post 21 not complied with. 21 you have to send to this. And it's an admitted fact that I do not live within the territorial jurisdiction of ALU. And Lordship will find that this is a case where the sum is phenomenal, Lordship. It's of 22 crores and some 64 lakhs. And it's highly improbable that I will not accept and not contest the suit and let it go. I wouldn't call a ex parte decree upon myself, Lordship. And be it as it may, Lordship will look at this various Supreme Court decisions, Lordship, which I have given. First is 2018 to SCC, page 649. That is the relevant, it's by the Honorable Chief Justice. And the relevant paragraph, I will not take too much of your Lordship's time. Relevant paragraph, Lordship will find from paragraph 13, where he quotes Order 5, Rule 17. And then, paragraph 14, evidently, as the report of the bailiff indicated, he was unable to find the defendant at the address which was mentioned in the summons. The report of the bailiff does not indicate that the summons were affixed on the conspicuous part of the house and the address mentioned in the summons. There was a breach of the provisions of Order 5, Rule 17. When the application for substituted service was filed before the trial court under Order 5, Rule 20, a cryptic order was passed on 2/9/2011. Order 5, Rule 20 requires the court to be satisfied either that there is a reason to believe that the defendant is keeping out of the way for the purpose of avoiding service or for any other reason, the summons cannot be served in the ordinary way. Substituted service is an exception to the normal mode of service. The court must apply its mind to the requirement of Order 5, Rule 20, and its order must indicate due consideration of the provisions contained in it. Evidently, the trial court failed to apply its mind to the requirement Order 5, Rule 20 and passed a mechanical order. Besides this, Lordship, this is the important part. Now, if Lordship looks at the order of the trial court, by which newspaper, it is a cryptic order, Lordship, no reasons recorded. Total non-compliance of this Order 5, Rule 20. The plaintiff is present along with the learned counsel, defendant found absent. The learned counsel found it has Lordship, the order 17, order dated 17/2 of the records. The records were there, I think.
17/2, yes.
Yes. Today, the present case is fixed for SR and WS. The plaintiff is present along with the learned counsel, Mr. Todak Ado. The defendant are found absent. The learned counsel for the plaintiff has submitted for steps by taken report. The plaintiff shall publish in any national newspaper for appearance of the defendants and issue notice to the defendants plaintiff to take steps. Now, this is the order. Lordship, where is the satisfaction that the service could not be effected? The defendants refused to accept the summons they were avoiding. There is no satisfaction as required, contrary to what the Supreme Court has clearly held, that there's no application of mind at all, whether the summons were properly served, whether the tracking reports were there to show. AD has not come back. The acknowledgement due is not there. No refusal, endorsement of refusal, nothing. He strays away passes this cryptic order. And it is not even seen that it does not even reflect whether the plaintiff prayed for substitution during publication. Nothing. Does not reflect anything. And then
It's not reflected that there was a petition filed for substituting services.
nothing is reflected. Nothing is reflected that the defendant refused to accept summons, that the summons were properly served.
General processing. General processing.
So, and in view of what the Honorable Supreme Court has said, this satisfaction is absolutely a must. Thereafter, Lordship, I'll place another decision of the Honorable Supreme Court, which is 2007-14 SCC, page 42, Indru Bhushan. Their Lordship, here the petitioner was residing in Bombay. Yes, Lordship. Lordship will can go direct to paragraph 11. A bare perusal of Order 5, Rule 9 clearly shows that service through the process of the court is mandatory. This position is clear from the use of the words may, shall in the provisions. In the instant case, not one of the several process servers have been given notice relating to the service, and the endorsements were sufficient to show service of notice relating to the appeal. Though correct, the same is not acceptable. No material is placed before this trial court or the High Court to show that the endorsement made by the process server was false or erroneous. Now, this is mandatory. This is what the court says, that Order 5, Rule 9 is mandatory.
But in your case, process server's route was never
taken. And if it's registered post, 21 would come into play.
Now, 21 post, was there a satisfaction drawn by the court in any of its orders?
Nothing, Lordship.
Recrossing to that General Clauses Act provision. 4 weeks gone. Satisfaction, nothing.
Nothing. Absolutely nothing. And Lordship, one last decision of the Supreme Court, which I'd like to place before Lordship. Huh? Short. It's a very short decision, Lordship. That is 2005-13 SCC, page 50. In the last, just 2 pages, in the last page,
What is the citation, madam?
the citation is 2005-13 SCC. Here, one was residing in Bombay, the plaintiff was residing in Punjab. Substitution news service, it was published in Punjab. So it was, they say it in a local daily, which the dissent actually is last known to have actually and voluntarily resides. In the instant case, the procedure prescribed under Order 5, Rule 20, which with regard to substituted service has been violated. In the premises, it cannot be said that the summons were upon the defendants were effectively served. This is what it says. So in view of this, Lordship, I respectfully pray that the ex parte order may be vacated and I may be allowed to participate in the suit before her. Otherwise, great prejudice will be caused.
My Lord, my humble submission would be that it is not the case of the petitioner that the address in the execution petition.
No, I got what you want to say, but tell me.
My Lord, I'm coming.
Tell me from this records that a satisfaction to that extent was drawn.
Yes, whether this satisfaction is necessary when an application under Order 9, Rule 13 was deciding whether it is necessary. Lord, say, have a look. In the CPC, my Lord, Order 9, Rule 13.
CPC.
My lord got it. This is basically, this FAO is basically challenging the rejection order passed in the application, which was filed under order, order 9, rule 13. What it says, my lord? Setting aside decree ex parte against defendants. In any case in which a decree is passed ex parte against the defendant, he may apply to the court by which the decree was passed for an order to set it aside. If he satisfies the court that the summons was not duly served or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, the court shall make an order setting aside the decree as against him upon such terms as to cost, payment into court or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit. Next proviso, my lord. Next proviso, yes. Proviso that provided that where the decree is of such a nature that it cannot be set aside as against such defendant, only it may be set aside as against all or any of the other defendants also. The next proviso is very important because, my lord, originally in the CPC 1908, this second proviso was not there. It was amended, my lord, in the year 1976. Why this amendment came out, my lord? The intent of the legislature, my lord, because provided further that no court shall set aside a decree passed ex parte merely on the ground that there has been an irregularity in service of the summons. If it is satisfied that the defendant had notice of the date of hearing and had sufficient time to appear and answer the plaintiff's claim. In that regard, my lord, I would like to satisfy your lordship with Honorable Supreme Court judgment, my lord. My lord, I'd like to refer one judgment. Because what senior counsel was assailing that there was irregularity in service. Basic argument was that, my lord. And in that regard, I would like to refer this judgment 2008 to SCC 326, Sunil Poddar and others. My lord can directly come to, first my lord may come to page 16. One more question they have raised, that regarding the paper publication, my lord. That will para 16, my lord. We are also inclined to uphold the argument of learned counsel for the bank that in view of the fact that the appellants were appearing before the civil court, it was not necessary for the bank to get summons published in a newspaper after the matter was transferred in accordance with law to DRT Jabalpur. But even that step was taken by the respondent bank in Nav Bharat Times, a Hindi newspaper having wide circulation in Bombay and Raipur. Summons were published. It cannot be argued successfully that appellants were not subscribers of the said newspaper and were not reading Nav Bharat Times. That was their argument, that they were not the subscribers and they were not the readers. Hindi edition, but even otherwise, such contention is wholly irrelevant, as to bills said that to have been produced from the newspaper agent to us, but the tribunals were right in observing that such a bill can be obtained at any time and no implicit reliance can be placed on that evidence. Next portion is important, my lord. It is immaterial whether the appellants were subscribers of the said newspaper and whether they were reading it. Once a summons is published in a newspaper having wide circulation in the locality, it does not lie in the mouth of the person sought to be served that he was not aware of such publication as he was not reading the said newspaper.
Now, Mr. Bedeka,
my lord,
you had published this in 2 papers?
3 papers. One is in Sentinel. It's a national newspaper, my lord.
Sentinel?
Sentinel, one is
Assam Tribune?
Assam, Dainik Assam, and one is Eco over Unasel.
So one of the respondents, respondent number 2.
Yes.
Is from West Garo Hills.
But respondent number 2 is not challenging the matter, my lord, here. The respondent number 1 is challenging the matter here.
Madam.
Defendant number 1, not respondent, defendant number 1.
Who is this defendant number 2? Madam, defendant number 2 is not before us.
Defendant number 2 is dead, Lordship. The suit has been filed against a dead person, which makes the entire suit. He was dead at the time of filing the suit. So the entire suit is vitiated.
Yes, I'm coming to that, my lord. Whether he was dead or not, that that information came out when this application was filed, not in the application.
So,
my lord, yes.
Here, at least before this court, the substitution ought to have taken place.
No, my lord, as this FAO was filed by the applicant, them. So there was no, maybe not necessary substitution, because this application was filed by them. And my lord, may come to para 19, my lord. The irregularity in service I was referring. Para 19, the down below, my lord. Bear reading of the above provision. My lord, got it? Bear reading of the above provision. Bear reading of the above provisions makes it clear that DRT and DRAT have, for the purpose of discharging their functions under the Act, the same powers. The Rule 13 of Order 9 was originally enacted what? It is stated here. And therefore, 20, the original Rule 13(9) of the Code does provided that when a decree had passed ex parte against the judgment, defendant who satisfied the court that summons was not duly served upon him, the court was bound to set aside the decree. It was immaterial whether the defendant had knowledge about the pendency of suit or whether he was aware as to the date of hearing and yet did not appear before the court. The Law Commission considered that aspect and expression duly served in its 27th report, the Commission stated. Either
can come to para 23.
Yes. 23. It is therefore clear that legal position under the amended code is not whether the defendant was actually served with the summons in accordance with the procedure laid down and in the manner prescribed or in Order 5 of the code, but whether he had notice of the date of hearing of the suit. Yes, he had the notice, my lord. And whether he had sufficient time to appear and answer the claim of the plaintiff. Once these two conditions are satisfied, an ex parte decree cannot be set aside even if it is established that there was irregularity in service of summons. If the court is convinced that the defendant had otherwise knowledge of the proceedings and he could have appeared and answered the plaintiff's claim, he cannot put forward a ground of non-service of summons for setting aside ex parte decree passed against him by invoking Rule 13, Order 9 of the Code. So, first one is that, my lord. My lord, it is not the case of the appellant that the address of the...
No, not on that. Now, in the impugned order,
yes,
show me this was satisfied. This conclusion of yours in para 23.
Yes.
The fines mentioned there.
I'm coming.
And how it is fined mentioned. How is it placed?
My lord will get from at page 20 in their FAO.
Page 20.
How the court has decided it. The second paragraph, my lord, having heard parties. Having heard parties, I have also gone through the case record of money suit number so and so. The suit was presented for the first time before the court on 27/11/2020, and notice was issued with direction to be taken by the plaintiff with registered post AD on defendants. And the case was directed to be listed on 15/1/2021. Accordingly, plaintiff is seemed to have taken steps on 13/12/2020 on both the defendants through registered post AD. Again, another steps were taken on defendants on 19/1/2021 in compliance to the order dated 15/1/2021. And case was directed to be listed again on 17/2/2021. On 17/2/2021, the leave was granted for substituted service by paper publication in one national dailies. And plaintiff, in compliance to the order, had published the advertisement of notice on defendants in English Daily, Sentinel, as well as in vernacular language in Assamese in Dainik Assam, of which both are the publication of Guwahati, where the applicant research on 26/2021. In addition to that, it is not disputed that on 26/2/2021 they were not there. In addition to that, plaintiff had made paper publication against the defendants in a local daily, and the address contained in the summon advertisement in the paper publication as well as notice in the execution petition are same. And before making order for substituted service, a considerable period had elapsed. This is the reasoning from issuing summon after notice. Thus, the court is justified in arriving to go for substituted service against the defendant in its order dated 17/2/2021, though reason is assigned.
Though no reason.
No reason is assigned. Further, the plea set up by the applicant that on until 25/2/2023, no summon was received by the applicant does not transfer confidence to the reliable, as the mode of service of summon in the execution petition is also through registered post. It is also through registered post in the execution petition. It was served, my lord. I have made one list of dates. It will help your lordships. That on 22/10/2021, it was decreed ex parte, my lord. Thereafter, 7/2/23, execution petition was filed. On 8/2/23, the stay notice was issued through registered post in the same address, which was issued, taken steps in the same address in the money suit also. So that was after receiving that notice, they came with this application under Order 9 Rule 13 on 15/3/2023. Now, my lord, one more judgment I would like to refer. Now, this burden lies on whom, my lord? This judgment clearly stated that. This is 2011, 3 SCC 545. This is the same, my lord, Order 9 Rule 13 application. Schedule gauge from 12, para 12. My lord. My lord, got it? It is evident from the above that an expert degree against the defendant has to be set aside if the party satisfies the court that summons had not been duly served or he was prevented by sufficient cause from appearing. It is the burden lies upon them, my lord, when the suit was called on for hearing. However, the court shall not set aside the said decree on mere irregularity in service of summons or in a case where the defendant had notice of the date and sufficient time to appear in the court. The legislature in its wisdom made the second proviso mandatory in nature. The second proviso is mandatory in nature, my lord. Thus, it is not permissible for the court to allow the application in utter disregard of the terms and conditions incorporated in the second proviso herein. So, what is sufficient cause, my lord? It is defined here. Sufficient cause is an expression which has been used in large number of statutes. The meaning of the word sufficient is adequate,
This is what I was going to say. Come to page para 70.
Para, my lord.
70.
Oh,
Ma'am, you have this judgment. 2011 3 SCC.
Yes, Lord.
545. 545.
Yes, Lord. 3 SCC. Page 545.
545. Para 17.
yes. Presumption of service.
Para 17.
Yes. That General Clauses Act thing which I was asking. They have dealt that here.
So presumption of service by registered post and burden of proof. So this court, after considering a large number of its earlier judgments in Greater Mohali Area Development Authority versus Manju Jain, held that in view of the provisions of Section 114, illustration F of the Evidence Act 1872 and Section 27 of the General Clauses Act 1897, there is a presumption that the addressee has received the letter sent by the registered post. There is a presumption, my lord.
Good.
However, the presumption is rebuttable. However, the presumption is rebuttable on a consideration of evidence of impeccable character. A similar view has been reiterated by this court in Sunil Kumar Sambhu Dayal Gupta Doctor versus State of Maharashtra. Next para, my lord. In Gujarat Electricity Board versus my lord, para 9. Okay. There is presumption of service of a letter sent under registered cover if the same is returned back with a postal endorsement that the addressee refused to accept the same. No doubt the presumption is rebuttable and it is open to the party concerned to place evidence before the court to rebut the presumption by showing that the address mentioned on the cover was incorrect, or that the postal authorities never tendered the registered letter to him, or that there was no occasion for him to refuse the same. The burden to rebut the presumption lies on the party challenging the factum of service. The provisions of Section 101 of the Evidence Act. In fact, burden of proof means that a party has to prove an allegation before he is entitled to a judgment in his favor. Next.
This one.
Yes.
Kind of that presumption of receipt of
Married?
or to the duly served. Presumption of service. Order 5, order 5.
Madam, how do you factor in Section 27 of the General Clauses Act here?
Lordship, the CPC, which is General Clauses Act, yes, but would apply, but initially there has to be this assertion that the summons was served and it was refused. The service.
I'm not on that. Section 21 says that if something is sent by the registered post at an address and the address is correct, there will be a presumption of its being delivered. Section 21, 27 General Clauses Act says so.
Yes.
So if the address that is being your address, that is where the first notice was sent, and the notice for the execution proceedings were also sent to the same address.
Yes.
It got delivered.
Yes.
So the presumption under Section, they may not, there may be some, just for my understanding.
Yes.
Then that presumption with regard to Section 27, whether that is available, and you have to bring on record material to rebut that also. Forget the substituted service. The initial
for that first instance, there has to be a proof that the registered service was effected. He has to give a tracking report or something, or assumption by the court, because it's presumed to have been received. That's a provision also in the CPC. Order.
Order 5?
Order 5, Lordship.
Order 5 rule.
Order 5, Lordship. I'll just give Lordship. Lordship, order 5, rule 9, sub rule 5. Sub rule 5. When acknowledgement or any other receipt purported to have been signed. Order 9, order 5, rule 9. Lordship will come to sub rule 5.
You come to the proviso, provided that where the summons were properly addressed, prepaid.
Yes.
And duly sent by registered post acknowledgement due, the declaration referred to in the sub-rule shall be made notwithstanding the fact that the acknowledgement having been lost or mislaid or for any other reason has not been received by the court within 30 days from the date of issue of summons. So 5, when an acknowledgement to be signed by the defendant so and so is received back by the court with an endorsement for putting
so there has to be a
Section
declaration.
27 parameteria is this.
Yes.
So there has to be a declaration or an acceptance by an order by the court. to
Yes,
that
Lord.
extent.
My lord.
So in that event,
My lord, in that case, again, I'm coming to the proviso, the second proviso of Order 9, Rule 13, my lord.
I got it.
Because
I got
why?
it.
Why I'm coming to that? In normal cases, in the normal ex parte decree,
Okay.
it happens, my lord, but not when an application is filed under Order 9, Rule 13. It cannot be because as
See,
as
I think
as my senior counsel has referred one judgment, the 2018 to SCC 649, that judgment was referred for Order 5 Rule 17. That when
process.
yes. Next one order 2007 14 SCC 42. It's a different one because this was an appeal filed under Order 41 Rule 21. So that can be done, my lord, but not under Order 9 Rule 13.
so Order 9, Rule 13, Order 5 is going to be given a go by. All the provisions, mandatory provisions. Order 7 is also applicable here.
The
Lordship.
Supreme Court is saying that,
Order
my lord.
17 also is applicable here, Lordship.
Supreme Court.
That's which is mandatory.
Does not
You
exactly
cannot
say.
get go by to a provision of the CPC, Lordship.
That is the substance. Order 5 is the substance.
My lord.
The Order 5 compliance has to be there. Whether it's a application under Order 9, Rule 13.
Yes.
We will have to see, the court will have to see whether say you do nothing. There is an ex parte order. You do nothing.
Yes.
The court just records, okay, steps taken, ex parte order gone. Files an application under Order 9, Rule 13. The court should blindly dismiss it.
No.
Or it should see whether that procedure has been followed or not.
In my humble submission, no.
My only thing now is.
But whether procedure was followed in my case, in the present case or not. Yes, the procedure was followed in the present case because he got the enough time to appear.
I'm not on that. That will come number 2. That's number 1. Now, say that Order 5 Rule 9, which
yes,
Madam has referred
I
to.
understand.
Notice presumption. We draw presumption here.
Yes.
So where is that presumption drawn?
My lord, no doubt presumption was.
Okay, give me another answer. The order that impugn or
But the presumption, whenever presumption is drawing that, my lord, the burden lies upon the addressee, my lord.
I know that, but show me that record. Show me that the trial court, while was there an application on your behalf for substituted service?
No. I think no.
Then how come this order came to be passed?
Court can show me to pass an order, my lord, if he satisfies, my lord. Since 2 times, my lord.
But see, there is nothing here.
My lord.
Submitted step taken report.
Yes, because
finished.
Submitted step taken report. Then we have submitted the step taken report, my lord. First date 15/1/2021.
So you give you give an application along with those.
Yes. Postal receipt.
Postal receipt. That's all.
Yes, my lord. So thereafter.
When was the step taken here?
My lord.
When did you take steps here? Give me the date. Madam, when was the step notice
may
first
be-
time sent to you? I think it's that impute order.
Lordship, I've given it in this thing when the steps were taken.
No, it's in
I mean, what they claimed, Lordship. We do not know.
27/11/2020.
Yes.
Yes. Judgment was, they just endorse, that will not do, Lordship.
No, just.
I can give anything. I can give a proper address, send it
And-
somewhere else.
My
The
lord,
envelope is not there before me.
On the last occasion, one more argument was enhanced, my lord. It was that, my lord, during that time, pandemic was
I still
there.
think-
During that time, pandemic was there.
Forget pandemic.
Means, my lord, impliedly they are admitting it. They had the notice, my lord.
Yes, I've got the dates now. I know when the pandemic was there.
No,
Where
ma'am,
is the
ma'am, it's okay, it's okay, it's okay. 27/11/2020 first day,
Yes,
when you took steps. Okay? 15/2/2021, 15/1 it should be.
15/1.
15/1/2021 is the next day,
Yes.
right?
Yes, ma'am.
15/1/2021, you were directed to take fresh steps.
Yes, my lord.
Huh? When did you take these steps?
That may be in the record, my lord.
Just check up. Because at least 30 days time
Yes.
after that required.
Yes.
So this order is passed on 17/2/2021. So whether that 30 days time on that day was over.
19/1.
Well, let's see.
Another steps were taken on the defendants on 19/1/2021. That's what I find from the records.
Your lordship,
From the judgment, Lordship.
what is the record?
At page 20 of my petition, of my appeal.
Madam, on the date the order for substituted service was passed,
Yes.
whether 30 days time from the date of issuance of notice by registered post was completed or not?
No.
Then
Because 19/1 it was passed, 30 days was not completed.
completed. Then how could he draw that presumption for substituted service?
My lord, on 26 to the next one, on 26 to 2021, paper publication was
No,
issued.
72 paper publication.
No, 26 to means for yes, on 17 to it was directed to publish, but on 26 to it was published in the newspaper. My lord.
No, I'm on the court's direction.
Yes,
Court passed the order on
because
72.
why I'm coming to that. General clauses act, whether it is satisfied or not. It is because the next date is 13/4/2021.
No, Mr.
Substituted service is also considered as the cogent service, my lord, because as Order 5 Rule 20, yes, 20. What Order 5 Rule 20 says, my lord? Effect of substituted service. Order 5 Rule 20 subclause 2.
Now see. Now this presumption in 9 subrule 5 proviso. Okay?
My lord.
Order 9.
My lord, may
5
kindly
rule
have
9.
a look at Order 20
You
Rule.
just come to order 9, order 5, rule 9.
Rule 9, okay.
Subrule 5 proviso.
Provided that where the summons was properly addressed, prepaid, and duly sent by registered post, acknowledgement due. The declaration referred to in this sub-rule shall be made, notwithstanding the fact that the acknowledgement having been lost
Or mislaid.
or mislaid
Or
for
having
any other reason
have not
has
been
not been
received
received by the court within
within
30
30
days
days.
from the date of issue of summons.
So 30 days time is there. How could it jump the gun? You took the steps on 19.
Not 1 minute.
Right?
My lord, the next one, 27. The first step was taken
on 15/1.
No.
No.
First step was prior to that because notice was issued on 27/11/2020. 30.
Just give me the records.
First step is not there, so. On 3/12/2020. 3/12/2020.
27/11, first notice issue.
Yes.
Fixing 15/1.
One.
So 15/1, you have fresh summons.
Yes.
For appearance, plaintiff will take steps.
Yes. The second step.
Second step.
Second.
So
On
you took
2012, on
registered post
3/12.
hearing in.
Yes.
You took registered post on 15/1, which was sent on 19/1.
19/1.
No, no, when
Yes.
did you send this?
No.
19/1, right, ma'am?
No, my lord.
Yes, Lordship, 19/1.
19/1 day notices were issued.
Is there any record, my lord?
Yes, so that's what the
Lordship, I'm referring to the judgment,
judgment is there.
page 20. Page 20 of my appeal.
Okay.
Again, another step was taken by the defendants on 19/1/21. So this is taking steps, right? In compliance of the order dated 15/1/2021. Now tell me.
Yes, my lord. My lord, have a look one more time. At para 20. Para 20. Sorry, page 20. Having heard the parties, I have also gone so on, presented for the first time, court on 27/11/2020, and notice was issued with direction to be taken by the plaintiff with registered AD on defendants. And the case was directed to be listed again on 15/1/2021. Accordingly, plaintiff is seemed to have taken steps on 3/12/2020. So it was seemed to be taken steps on 3/12, my lord. So more than 30 days.
No.
Next date.
3/12, 15/1.
And 15/1.
15/1. Oh, 15/1. Okay, 30 days.
More
fine.
than 30 days.
Now, what happened on 15/1? 15/1?
15/1 again.
Further order to take fresh steps.
Again, another steps were taken on defendants on 19/1.
No, no. 15/1, further order to take steps, right?
Yes.
That
was taken on 19/1.
19/1.
Yes, maybe.
Then-
But the first one was taken complying the General Clauses Act, my
No,
lord.
no. First one,
So
forget
why
it.
do you replace CPC with General Clauses Act?
No. First one, you forget it.
Even CPC, Order 5.
First one, forget it. Court has not accepted that. That is gone.
My lord.
Court has granted you further time. I'm not on that. I'm on something else.
Yes.
Just wait. Now, 15/1, you took steps on 19/1.
Yes, my lord.
Now, 19/1 clause 5. Proviso to
9 proviso.
By order 5, rule 9, sub-rule 5. Proviso.
Yes.
30 days.
My lord.
Right?
Yes.
What made this court to act in the matter before 30 days? On 17th. We are on procedure.
My lord, I understand.
Why was it so up and going?
But whether, again, the same question
No.
will rise, my lord. Whether the
Because-
irregularity in service.
There is two things here,
My lord.
which you must address.
My
One,
lord, yes, my lord.
one, why was that declaration under 9/5 not made?
My lord.
On the date when the substituted service was directed, that declaration or no, why it will not declare was not there. Two, if we have to presume, we would have presumed that if that was there, if that declaration was there, then that judgments would have come into play.
Yes.
But today, you are contending that the appellant here had time to come, but he did not come.
My lord.
But we are on the question whether he had knowledge.
Yes.
And the court's only plea is that the notice was served in the execution petition upon the plaintiff. So he knows it. So same address it was said. But that satisfaction, where was it drawn in the money?
I understand. This query, my lord, regarding order 9 Order 5, Rule 9 proviso, my lord, subclause 5.
We are not going with madam's thing. Madam has said something, let her be.
My lord.
But what is this?
This needs to be looked again, my lord.
No. Now you come to clause 20. So rule 20 of order 5, substituted service.
Yes, yes. One proviso, my lord. Where the court is satisfied that there is reason to believe that the defendant is keeping out of the way for the purpose of avoiding service, or that for any other reason the summons cannot be served in the ordinary way, the court shall order the summons to be served by affixing a copy thereof in some conspicuous place in the courthouse, and also upon some conspicuous part of the house, if any, in which the defendant is known to have last resided or carried on business or personally worked for gain, or in such 1A. Where the court, acting under subrule 1, orders service by an advertisement in a newspaper, the newspaper shall be a daily newspaper circulating in the locality in which the defendant is last known to have actually and voluntarily resided, carried on business or personally worked for gain. It was complied, my lord.
No. There has to be a satisfaction law.
Yes.
That the notices that were issued were received.
Yes.
But he is not come.
My lord.
He is avoiding. Where is that? Or it should be presumed that there is no recording of reason required.
Though reason was required.
Madam, what is the position? Just for my clarification. Substituted service, if I have to order under Rule 20 of Order 5.
Yes.
Is a finding to be recorded that with regard to their opening lines, Order 20, Rule 1, opening lines.
Yes,
sorry, Order 5, Rule 20, opening lines. Where the court is satisfied that there is a reason to believe that the defendant is keeping out of the way for the purpose of avoiding service, or that for any other reason the summon cannot be served in ordinary way, the court shall order. Now, other part is not required, 1A it comes. Where the court is acting so and so, service via advertisement in a newspaper. Now, before I direct for issuance of an advertisement in a newspaper, am I required to record any reason for that in my order?
Yes, Lordship. Yes, Lordship.
I am required. Can you just substantiate that, ma'am?
Yes. Lordship, I think in the just paragraph 14, Lordship, of the judgment of 2018 2 SCC
649.
Supreme Court, Lordship. Evidently, the paragraph 14.
Yes.
Evidently, as the report of the bailiff, but that I'll not know, the report of therefore, as a breach of provision of Order 5, Rule 17, when the application for substituted service was filed before the trial court under Order 5, Rule 20, a cryptic order is passed on 29/2011. Order 5, Rule 20 requires the court to be satisfied either that there's reasons to believe that the defendant is keeping out of the way for the purpose of avoiding service, or for any other reason, summons cannot be served in the ordinary way. Substitution service is an exception to the normal mode of service. The court must apply its mind to the requirements Order 5 Rule 20, and its order must indicate due consideration of the provisions contemplated.
That will do.
Now, my
This was just
Yes.
something troubling me. Now I have got it.
Yes. I have got this judgment. Even I, I have also this judgment. So, what this judgment said, my lord, I have read more than 5 times, my lord. This was basically when a person cannot be found or when a service was refused to accept. In that situation, this can be done, my lord, but not in our circumstances, my lord.
See, sending by post.
Yes.
And sending a man.
Yes.
Man reporting back that the man is not found. And this is more in vagueness that registered post.
My lord.
This is not the intention here. The intention here is that before the court passes an order for substituted service, it must indicate due consideration of the provisions. Due consideration is that 2 opening lines.
My lord.
Right?
My lord.
But in our order, the order here, nothing.
May not be. There may not be any reasoning. Whether the law requires the reasoning, my lord. In substituted service, my lord.
You find out a judgment to that effect for me.
I'll do that.
Find out.
I'll try to.
Tell me that without by drawing, even if there is no presumption drawn, well, forget 27 or Rule 5, that you are avoiding service. Even if it is not, well, still without any further ado, the court can go and go take substitute service. 1. Second would be that in view of General Clauses Act 27, as well as incorporated in Order 5, Rule Order 5,
9
Rule
subclause 5.
Subclause 5,
Proviso.
proviso. Now, if that declaration is not there, what would be the effect?
Well, I'll find out.
What would be the, because provided that where someone was properly addressed, prepaid, and duly sent by registered post, the declaration referred to in this shall be made, notwithstanding the fact, so and so, so and so, so and so.
Yes.
So, once that declaration is there, that's the end of the matter.
I got that. Whoa. What
But
Lordship
if
pointed
that
out.
is not there, then the knowledge you cannot impute to madam. The knowledge.
Anyway, he cannot bring in General Clauses Act here, Lordship.
No, I'm not on General Clauses Act. I'm on that Order 5, ma'am. Order 5, rule. No, I'm on this.
Rule 20.
Rule 9.
Rule 9. Rule
9. Sub-rule 5, proviso.
Proviso.
30 days. And here he has not even waited for that 30 days.
I'll find out, my lord. I'll try to. Because when I got this judgment, Nirja, what ma'am was relying on, it gives me headache. Because I know whether it was pointing out. But, my lord.
We are satisfied that she did not have knowledge. Now you try to, this is a tentative thing, my lord. You try to.
I'll do that, my lord.
Giving him one more chance, ma'am. He wants, let him have it. Let him satisfied. If he can show something, sure. Don't go into the General Clauses Act. I just brought it.
Yes.
The provision is there in the end.
In the CPC itself.
You took the steps on 19. He passes an order of substituted
15.
service on 17. 17.2. Without satisfying those 2 opening lines. And there is no finding recorded that you have been avoiding. Or they have been avoiding appearance in spite of having knowledge.
If I am calculating correctly, from 19 to 17, 19.1 to 17.2, it would be the last day on 17, because if I took steps on 19, so then whether the day will count from the day itself or
You
from
have
the
to
next
take
day.
30 days.
31 days January, my lord.
30 days. Okay, fine. Whatever it is.
Yes.
We normally will say that 30 days would be
Understand.
a date which will be akin to that. So, I'm not even sure whether there was a note put up.
No, it was not there, I think. I couldn't find out.
When?
The complete records are not there, Lordship.
Complete records are not here. It's here, pura nahi aata hai, कि हम लोग यहाँ पे.
Complete records are not there.
Anyway, what we require is here. so we'll fix it.
Already in the order itself.
But how far the orders are correct? Because the orders not all
Or you want me
correct.
to call for the entire records, ma'am?
Lordship, it will only delay it.
That's it, what I said. You get anything which you have to dispel this notion.
My lord, I'll do that.
When?
On 12th, my lord. My lord will be here on 12th.
I'm here. Okay.
On 12th, Lordship?
12, we'll close it, ma'am. Just giving
Yes.
him an opportunity to bring on record this thing.
Yes, Lordship.
12.
My lord.
You try.
Obliged.
Heard the parties. So, Mr. B. Dhaka, London. Counsel appearing for the respondent. Praise that we granted one more week's time to place on record judgments in support of his contentions, further judgments in support of his contentions. Full stop. List the matter again on 12/3/2024 as a fixed item. Madam, at 2 p.m.
Obliged.
2 p.m. At 2 p.m. Just that narrow thing, if you can get something like this.